Funding for Policy Watch with Doug Besharov is provided by the Norman and Florence Brody Family Foundation. In the mid-1990s, the U.S. Office of Holocaust Issues helped secure $8 billion in settlements for Jewish and non-Jewish victims of the World War II Nazi occupation. From some of the most powerful firms in Europe, they recovered in return looted art, confiscated property, and cash held in long-dormant bank accounts. In addition, those held in wartime forced labor camps in Eastern Europe finally received compensation for their suffering. But this effort raised an important issue. If Holocaust victims deserve payment, what about the descendants of slaves, victims of apartheid, those interned and displaced in wars all over the globe? Should these victims also be compensated for man's inhumanity to man? For Part 2 of Imperfect Justice, Looted Assets, Slave Labor, and the Unfinished Business of World War II, Policy Watch is joined again by Stuart Eizenstat, former Deputy Secretary of the Treasury and Special Representative of the President and Secretary of State for Holocaust Issues. Now, from the University of Maryland, the host of Policy Watch, Doug Besharov.
Stu Eizenstat. Welcome to Policy Watch and the University of Maryland. You know, I think of myself as a relatively well-informed person, and I can picture families, neighborhoods being trooped off to the railroad cars. But somehow I never asked myself, well, what happened to their possessions? What happened to their bank accounts? What happened to their artwork and their property?
Well, Doug, frankly, that is the common view, and it's why it took 50 years after the war for this issue to come back on the agenda. And indeed, the victims themselves were so intent on trying to make a new life in a new country, whether it was Israel or the United States, that they rarely talked about these possessions themselves. What we're facing, and what I describe in both the book and the work I did as President Clinton's special representative on Holocaust issues, was in effect to bring back an issue that had not been on the world agenda for 5 decades. And one of the real dilemmas that the early Israeli government had was whether to seek restitution from Germany. One of the hottest political debates Israel has ever had, including over the future of the territories today, was between David Ben-Gurion, the first prime minister of Israel, and Menachem Begin, then the leader of the opposition. It was violent because Begin opposed Ben-Gurion's effort to go to the Germans and seek money for their own survivors. Begin said, whoever heard of someone whose family has been murdered going to the murderer for money? But there was an essential need to assimilate this huge block of refugees who streamed in finally from the displaced persons camps and from camps in Cyprus and became Israeli citizens. Israel simply had to seek the money from Germany. But even then, Doug, they never directly negotiated. They created something that still exists in New York called the Jewish Material Claims Conference, in effect a non-governmental organization, to be their representative to negotiate with the Germans, because the whole issue was so white-hot that the notion of a government-to-government negotiation so soon after the war simply was something the Israeli public couldn't tolerate.
And they tread quite lightly on the Eastern European countries as well, didn't they?
Yes, in fact, 50 years later, when I started to get involved, and my first assignment was getting communal property back for the Jewish, Catholic, and other communities, churches, synagogues, schools, community centers, even cemeteries, so that they could rebuild their shattered religious communities after the end of the Cold War, when, of course, during the communist era they couldn't practice it. I would frequently go to Israeli prime ministers, first to Bibi Netanyahu and then to Barak, and to Israeli ambassadors in Eastern Europe, and I said, look, President Clinton's given me this assignment. You're the natural spokesman for the Jewish people in Eastern Europe. How about giving us help? They wouldn't raise a finger because, again, it was not a priority. Their priority was to reestablish diplomatic relations with the former communist countries. They let us do the heavy lifting. And then it was like peeling back the layers of an onion. One discovery led to another, and we moved from property restitution in Eastern Europe to Swiss banks to German and Austrian slave labor employers, and then to the French banks. And as I think we know in this country, anytime there's controversy, there are going to be lawyers, and I can say that being one. And here there were massive class action suits brought by a very colorful, discordant group of class actions lawyers against the Swiss bankers, against the German and Austrian slave labor employers, the Siemenses and Volkswagens, and yes, Fords and IBMs, and against the French banks. And I became the, in effect, unintended ringmaster of a three-ring circus, the mediator in all these suits, and we ended up with $8 billion in recoveries for victims.
A number of times you've mentioned the problem of American slavery and some kind of, let me use the word that's used, reparations. Now, the efforts that you made for the victims of the Holocaust tended to be limited to living, surviving victims. And of course, no one is alive now who survived American slavery. So how would you apply the principles that you developed to the American slavery issue?
I'll answer that directly, but I want all of the viewers to understand what we were doing was not a Jewish exercise. The majority of the money, the $8 billion, goes to non-Jewish forced laborers in Eastern Europe who never have been paid over 50 years by the Germans. I think that there should not be compensation for African Americans today for their great-great-great-great-grandparents, if they could even identify them, for slavery, because we made the very tough decision to limit payments for slave and forced laborers only to survivors. In 1988, when Congress paid Japanese Americans for their internship, they only paid those who were living. But that's too easy an answer. There's never been, as we got from the German and Austrian presidents, there's never been a presidential apology in 150 years for slavery in the United States. My way of recompensing African Americans today for slavery 150 years ago is not by paying, again, their great-great-great-great-grandchildren, but rather affirmative action. Because it was not the Emancipation Proclamation in 1863 that ended discrimination against blacks or African Americans. In my own lifetime, as I mentioned, I grew up in a segregated system. I know the impact that discrimination has had. And I think affirmative action is a way of saying we owe the black community something and we're going to pay for it in this way.
I know that you feel there are lessons for your experience in other geopolitical areas. And in fact, while you were still at the State Department, I think you got a call from Madeleine Albright asking the applicability of your experience to the Palestinian-Israeli conflict. Maybe you could tell us a little bit about that.
I think that much of what we did could have applicability to the solution in Iraq, in the Arab-Israeli conflict, of these kinds of conflicts.
Tell us about the Madeleine Albright call.
Indeed, Madeleine Albright called me in July of 2000 from Camp David during the Arafat-Barack Clinton summit. And she said that Arafat has just put on the table in the 11th hour the Palestinian right of return to in effect, what they call Palestine, Israel, to get their property back. And she said, you've been doing all this property restitution. What do you got to say about this? And after gulping several times, I said, well, there are obvious differences. There's a historical issue about whether they were really driven away or left voluntarily. But I said, there is actually some applicability, because what we've done in Eastern Europe, Doug, we know that you can't always return people's real property. It's often occupied by people who have purchased it in good faith, apartments, school buildings, and so forth. You can't just move people out. So what we encourage countries like the Czech Republic and Poland and Hungary to do is to create compensation funds. And that's what I suggested to Madeleine, that in effect there be an international donor fund to which a number of countries, including Israel, can contribute. And in lieu of giving back houses and businesses that the Palestinians left in 1948 during the War of Independence, pay those people in refugee camps, something, by the way, that other Arab governments have never done after 50 years, to get them out, and we can call it, in effect, a humanitarian payment. The Palestinians can call it a recompense for their property, and I think that's one of the ways to solve this terrible problem, and ultimately we'll have to deal with the right of return if there's going to be a final settlement.
Well, everyone wants me to ask. So What did she say, and what did he say, as in Arafat? What did Madeleine Albright say?
She frankly agreed, as did the President. The President proposed to Arafat that he would take the leadership in creating a multi-billion-dollar international donor fund for just this purpose. Arafat unfortunately turned all of the offers down, that and the territorial compromises that Barack made, and we know obviously the terrible consequences that have followed.
But as you probably know, there has been a poll of Palestinians. The pollsters have since been attacked, physically attacked, but there has been a poll of Palestinians, and more than 90% do not want to go back to their homes.
Yes, and they would be more than satisfied with these kind of payments. And by the way, I think in Iraq we can use a similar concept.
You have indeed proposed that.
I have. I've proposed, for example, with respect to Iraq, to bring reconciliation, that you have a historical commission like the 21 we created to look at Saddam's brutality, to allow people to testify to what happened, to have those who were victims of torture and slavery, just like the slave laborers in World War II, be able to recover out of some of the oil revenues, to have the property disputes between the Kurds in the north and the Iraqis, the indigenous Arabs, that will have to be resolved if we're going to have some peace in northern Iraq, be resolved with similar property commissions to that which we created in Eastern Europe. So I think there's a lot of applicability to what we did to the solution of modern conflicts.
I think what I will do right now is turn to our audience to see if they have what questions they might have. So could I ask people from the audience who might have a question to come to the microphone? Come on up. And please come on right up to the microphone as you can. And why don't you introduce yourself so that our guest knows who you are?
My name is Greg Crosswhite. I'm actually a junior undergraduate here. I'm a math, physics, and computer science major. I was wondering, you've talked a lot about, I guess, talking to other countries and convincing them to set up things like funds and studies. And what I'm wondering is, what means do we have of pressuring these countries to do things that they obviously would rather not do?
That's a very good question, and I think that the answer is, if I had been a representative of another country trying to obtain from the Swiss or the Germans or the French or the Austrians similar efforts at justice 50 years later, it would never have worked. The reason why it worked here was because I was representing the United States of America. And we can be very proud of the fact that the United States of America stands for certain moral and ethical values. It's the great superpower in this world, and when the United States speak, other countries listen. We have an enormous market for their products. We're often key suppliers of military assistance and financial assistance, and so when we speak, they listen. And that means, of course, we have to be very careful about how we use that power, but when you use it in a way to do justice for victims, and that's what we insisted on, these other countries perked up and paid attention in ways they wouldn't have, again, if another country had made the same request. One of the great conflicts that I had, in fact, Doug, this was a sort of interesting aspect, I was really trapped in effect between conflicting forces. On the one hand, I obviously wanted to help victims, Jewish and non-Jewish, of this genocide get their assets back. At the same time, I was trying to preserve our foreign relations with valued countries, Switzerland, Austria, Germany, France. These were allies.
Feel free to leave off France from that list these days.
Well, that's another story. But the fact is we were, in effect, caught in between. And we were trying to accomplish both justice without disturbing our foreign policy and economic relations too greatly. And that did cause a certain conflict.
Yes, sir.
My question is about the deal with the Swiss. And I'm wondering why no one has suggested using the World Court to try them as war criminals. I mean, it seems like what they did was pretty egregious, and $8 billion doesn't seem like very much money. And there's a court in The Hague that has dealt with similar issues in the past, and I'm wondering if that has ever come up. But I also want to thank you for your support for affirmative action. It seems like nobody's speaking out enough for that. So.
Okay, in terms of, you're saying using The Hague?
Yes.
Yes.
The Swiss as war criminals.
The Hague is usually used for disputes between countries. And here we were dealing with private corporations. I mean, that's what was distinctive about our negotiations. It was holding private companies, private Swiss banks, private German and Austrian and French companies responsible for their cooperation in directly or indirectly facilitating the theft and indeed even the genocide of people. And so The Hague is not normally the place one brings that, number one. Number two, we didn't have a choice of the forum because the lawyers brought these cases in American courts. And it was the American court system and the spotlight that was shined on these foreign corporations in an environment they had to sell in that gave it a special relevance. I mean, to give you a perfect example. At the time Volkswagen was sued as one of the many German slave laborers, they were about to reintroduce a new version of the Beetle. The last thing they needed was publicity of what they had done 50 years before. Another example, the class action lawyers were quite ingenious about this. They took a full-page ad in the Washington Post, New York Times, Wall Street Journal against Bayer, the maker of aspirin, which of course was a German slave labor employer. And it said, if you want a real headache in the United States, you'll refuse to settle these cases. But normally, when you conduct foreign relations, it's government to government. Ours were sort of a democratization of foreign policy. We were dealing with non-governmental organizations like the World Jewish Congress, with class action lawyers, with private companies, with governments that saw their private companies as representatives of their own country. So we were dealing, except in Switzerland, where the government refused to ever negotiate with us. The German government, the Austrian government, the French government also negotiated along with their private companies.
But I do want to press you on that because I'm a little hesitant to see American law used that way. So I'm hoping that you'll say, yes, but it was mainly politics. It was mainly sanctions. It was mainly the pressure of the U.S. government. I'm hoping that's the answer because I'm worried otherwise about the use of the courts at a time when American foreign policy may not be aligned with these legal remedies.
No, frankly, one has to say that whatever one has in mind for class action lawyers, and I certainly bear more lashes from them than perhaps I do from the Germans and the Swiss and others, had it not been for their suits, I don't think we would have gotten anything like the results that we did.
Really?
It was those suits that led to my intervention. And may I say that many others are now, for better or for worse, following that practice of trying to correct historical injustices through the court system. Just within the last 18 months, Doug, Korean comfort women forced into prostitution by the Japanese have used U.S. courts to sue the Japanese. American POWs who were captured by the Japanese in the Asian theater of the war and forced into their own slave labor are now saying, well, look, if Eastern European Jews and non-Jews can recover, why shouldn't we? Anti-apartheid victims in South Africa are suing U.S. companies alleging that they participated in the apartheid regime in South Africa and are seeking recompense. And indeed, African Americans are now using the same legal theory to try to get recovery for slavery 150 years ago. So this is, for better or for worse, proven to be a whole spawning of an industry of class action lawsuits seeking to rectify through the court system, which may not be the best avenue, historical injustices. But remember, those are injustices that were not being corrected through other means.
Let me ask you this question. Should the American government, in the form of the president, maybe the Congress, be able to turn off those lawsuits? I believe the president has already tried to stop some lawsuits against the regime in Iraq. I think he's already helped.
Yes, the Bush administration has taken a position against many of the suits that I've just mentioned. I think the answer is that the courts are not the best vehicle, that they do interfere with the conduct of foreign policy. But that's too simple an answer. If an administration wants to suggest that these cases should be dismissed because it does interfere with the president's foreign policy, then the president has the obligation to exert his moral authority to get a result for victims through diplomatic means. And what's happened, unfortunately, in this administration is they've sought to dismiss the cases, but without also putting the moral suasion of the U.S. government behind the effort to get victims a recovery. Japan is a very good example. The Japanese, now we're talking about, 60 years after World War II, have never paid a nickel. There was $90 million in frozen assets that were taken after the war, and that's it. Germany has paid $60 billion, and then they paid another 10 billion Deutschmarks, $5 billion, in our negotiations for slave and forced labor. Japan has paid nothing. Why? Because the treaty between the U.S. and Japan after the war, the San Francisco Treaty, barred any future suits. Okay, that may be a ground to dismiss American POW suits, but it's not a basis for the administration to then wash its hands of the whole issue. We should be saying to Japan, this is an obligation you have. You should meet it. There are 6,000 American POWs now in their 80s who have never gotten a nickel for being forced into slavery during World War II.
Hi, I'm Jerome Siegel, also from the Institute for Philosophy and Public Policy here at the university. I wanted to go back to the question that Madeleine Albright asked you about the applicability to the Israeli-Palestinian issue and the policy recommendation that President Clinton made. As I understood what you were saying before, you were saying that you thought, in fact, that the Palestinian refugees might, in fact, have some legal and moral claims, I assume, with respect to property that they either left behind, was abandoned, or however you wanted to characterize it. But the policy instrument that was recommended was some kind of international fund that the United States and others would contribute to. And to me it seemed as if there was a disjunction there, that if they have claims for this property, it would seem to me that the claims are claims against either the Israeli government or individual Israelis rather than towards the international community. Now, I can understand from a practical point of view that you could get more funds and so on, but I wonder from a conflict resolution point of view if there isn't actually an importance both for the Israelis in facing the experience of the refugees and for the Palestinians in feeling that in some sense justice has been done for in fact the claims not only to be placed on the Israelis but for the Israelis themselves to contribute to this almost entirely and to contribute quite generously.
First of all, I think that the legal claims by the Palestinians are somewhat dubious and doubtful because the whole circumstance under which they left what was then Palestine during the war is itself subject to great debate. There are many historians who argue quite persuasively that most, although not all, left voluntarily, having been told by other Arab countries, leave so we can wipe the Jews out and push them into the sea and then you can get your homes back. So it's not clear how much was confiscated. Number two, you have the added complication of those Jews who were forced out of Arab countries and have now gotten into Israel in North Africa and Iraq and Syria and lost their homes. So if you're going to recompense one, you have to recompense the other. Now, having said that, I think your point is a very important point. I think as a matter of reconciliation and morality, not legal claims, that this international donor fund that I believe will be created at some point if we ever get that far, and we were perilously close, or I should say enticingly close to that point in 2000 at the summit, I think that Israel should contribute, and I think it will contribute. But they will view it as a humanitarian gesture, as will perhaps the United States and others, and the Palestinians may consider it as a legal gesture. That's what diplomacy is all about. You come up with solutions that each can interpret in different ways, but you come up with a bottom line result.
I just wanted to respond to what you just said. I'm a bit surprised what you said about two things. One, about the explanation of the refugee problem. I mean, my understanding is that the Israeli historians that have looked at this have concluded that there's a question of fact as to whether or not there ever were any such requests to the Palestinians, but that the explanation as to why most Palestinians exited is really a breakdown between those who were forced out and those who fled. But I would wonder, from either a moral point of view or a legal point of view, there's a war going on. Let's say somebody flees, and they're not forced out, but they flee with an intention of getting out of the fighting and an intention to come back as soon as the fighting dies down. And yeah, they're Palestinians, so clearly they had a preference as to who should win that fighting. But how does that affect whether or not the land that they owned, whether or not they lose title to that when Israel refuses them the ability to re-enter and reclaim it?
Well, because I think when you're in a wartime environment and you have two parts of a society that are fighting each other, that in terms of international law, it's not at all clear that the victor is responsible for returning. Now, if you occupy someone else's land, this is where you get the West Bank and the post-1967 Six-Day War issue. Under international law, you're not supposed to change the status of those quote-unquote occupied territories. That's not the case with what is now sort of historic Israel, where a country is actually fighting for its own existence in a war of independence. The requirement of returning property there is much less clear, much less clear.
Well, I think that's the last question that we have time for. Stuart Eizenstat, on behalf of the University of Maryland and Policy Watch, thank you very much for being with us.
Funding for Policy Watch with Doug Besharov is provided by the Norman and Florence Brody Family Foundation.
We are PBS.